or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Wwnn, Flynn & Kubler, where we specialize in intellectual property, including patents, trademarks, and copyrights, as well as elder law. You can find out more by visiting us online at oltmanpatent.com. That's oltmanpatent.com. You can also view all episodes of this show on our website. I'd also like to acknowledge our other sponsor, Fresh Start Tax. Fresh Start Tax offers a full range of accounting services, including basic tax returns, as well as assistance with tax levies, wage garnishments, and any other tax-related concern. You can visit them online at freshstarttax.com. I'd like to wish everyone a Happy New Year. Hope everyone had a Happy New Year. This is our first show in 2015. I'd like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. If you have a question, comment, or story that you'd like to share on the air, please feel free to call us toll-free at 888-565-1470. Once again, that toll-free number is 888-565-1470. We welcome your calls. This evening, we're going to be discussing the historic legal moment that occurred today, which is same-sex marriages are now officially recognized in Florida, pursuant to a federal district court ruling that happened a few months ago, and a stay on the injunction that the court ordered that officially lifted yesterday at close of business. And we have had some midnight ceremonies, marriage ceremonies, and now all clerks of court in the state of Florida are required to issue marriage licenses. With me to discuss this issue is attorney and partner of his law firm. This is Jeff Brown. He's an attorney with the law firm Laval, Brown & Wwnn. Jeff specializes in a number of areas of law. He's a mediator. He practices general civil litigation, including personal injury, as well as criminal law. So, Jeff, thank you so much for joining us this evening.
My pleasure.
So, like I said earlier, this really is a historic moment. I'd like to take a few minutes to discuss the background of this case. It was a case that was in federal court, multiple plaintiffs that were consolidated into one case, and the judge ultimately ruled with respect to same-sex marriages. There were same-sex couples that were trying to get marriage licenses in Florida, and they were denied because Florida previously does not recognize same-sex marriage according to the Florida Constitution and Florida statutes. But the judge ruled that the Constitution of the United States requires that same-sex marriages be recognized because the right to marry is considered a fundamental right. So, as we've seen the fundamental rights be defined by the Supreme Court, and we've seen it evolve over the years, how do you view this moment in history?
Well, it's unique, and here we are with it. A fundamental right kind of means it's something that is very hard to take away. The amendment doesn't list all of your fundamental rights by name, so this is something that evolves in the court system, and it being recognized as a fundamental right puts it right up there with a historic moment.
And again, we should talk about the Constitution. The Fifth Amendment, as it applies to the federal government, the 14th Amendment applies to the state government, to the states, and they basically say the same thing, which is that the government can't take away your life, your liberty, or your property without due process of law. In this case, we're talking about liberty. We all know what your life is. The government can't take your life. They can't take your property without due process, without a trial or something like that. But liberty is a relatively vague term. It can mean different things to different people. And the courts have generally held that rights that are fundamental are things that the government's going to have a much harder time taking away. We've seen in this case, the judge was very adamant that the right to marry is fundamental, and there are circumstances where in the past that the right to marry the government has banned certain circumstances. Interracial marriage, for example, was a historic moment when the Supreme Court ruled that interracial couples must be granted the right to get married, as well as some other circumstances. So what do you think about that comparison, Jeff?
Well, I think it's a good comparison because, moral disapproval, it cannot be the standard. Whether you're in favor of interracial marriage or same-sex marriage cannot be the determinant. In other words, it's not a popularity contest or really a morality kind of interest that can sway the day. So it being a fundamental right means that, states can't differ as to whether they're going to recognize a fundamental right, and that's why it's sweeping the country. And about 70% of the states now allow it. I think Texas being one of the big exceptions. But I think it's the wave of the present that it now having been named a fundamental right means it's here to stay, in my opinion.
And, this is a fundamental right and under the Constitution is something that we don't leave up to the will of the majority. Or our founding fathers, when they wrote the Constitution, we really don't know what they were intending necessarily, but they did say that we have the right to liberty. So,
and that's why the interracial marriage is obviously something you can look back on, and it's not a question of who likes it more or who likes it less, but whether you can prevent the exercise of a fundamental right.
And the right to marry has also been examined in other cases as well. There were some states, for example, that would ban marriage for prisoners, people that were incarcerated. The courts ruled that you can't do that. The right to marry supersedes any interest that the state might have in preventing prisoners from getting married. Other circumstances, including laws that would stop former spouses that owed child support or alimony from getting married to a new spouse, that didn't work either. That's something that the state cannot do because it is a fundamental right. And so the way that the state of Florida tried to argue its case unsuccessfully here was they tried to say that the right to same-sex marriage is not a fundamental right, as something that's distinguished from the general right to marry. And that's just something that the court said was a non-starter.
Yeah, I think the court didn't find much weight in that kind of an argument because it's really a morality argument, of what people might think or argue is morally correct or morally something they approve of. And the court dismissed it.
Right. And this is something that is a part of the constitutional analysis, is that in order to take away somebody's liberty or somebody's freedom, and there are circumstances where the state can do that. That's why it says they can't take away your life, liberty, or property without due process of law. So there are circumstances where they can take away your freedoms, but at the very least, the state's required to put forth some sort of a state interest. They have to put forth a public purpose for why they're doing what they're doing. And in this case, all they really had was moral disapproval. They really didn't have anything else, and that's just something that isn't enough.
Yeah, they require a compelling state interest and kind of narrowly define, and you've got a bit of a burden to show a compelling state interest beyond moral disapproval or popularity contest, and that's where they couldn't demonstrate that.
Right. Also, if you have a fundamental right that is being taken away, under a lot of the cases from the Supreme Court, they've said that there's a presumption that the law is unconstitutional. I didn't see that here, but that's an interesting take on it. Which really brings us to an obvious comparison with polygamy, because that's always part of this debate as to whether if there's a constitutional right to same-sex marriage, then there would have to be a constitutional right to polygamous marriages, since it's an individual freedom right that people have. The government can't define it. And it is interesting because the argument against polygamy is in some ways similar to the argument that same-sex marriages can be banned, which is that people disapprove of it. But it's going to be interesting to see if additional cases come down the pike in which polygamous marriages are, or people that are trying to enter a polygamous marriages challenge laws that ban those marriages, to see how the state would respond.
Well, it would seem like the next logical step, if it's a fundamental right to marry, why is it limited to a singular marriage as opposed to plural marriages or multiple marriages? And the states will argue that there's compelling state interests, in banning it, and they'll have to deal with the whole constitutional framework. But that probably, could come next.
That could definitely come next, and it's going to be really difficult to predict what will happen. I'd like to talk a little bit about one of the arguments that the court rejected here, and that's been offered, that was offered by the state in defense of the ban on same-sex marriage, which is the argument that marriage has to do with procreation, that because same-sex couples couldn't biologically procreate, that was a reason to prevent them from getting married. The judge just absolutely rejected this argument, taking the position that there are many opposite-sex couples that are equally unable to procreate due to medical reasons, age, when somebody passes the age in which they can have children, or opposite-sex couples that simply have no desire to procreate. In other words, the willingness or ability to procreate has never been a condition for marriage with opposite-sex couples, and so it's just not something the court could take seriously with respect to it being offered as a justification for same-sex couples.
Yeah, the court took the justification and said, if we went down that road, you wouldn't have elderly marriages. You wouldn't have marriages where there's a medical condition, either male or female, that would prevent procreation. And I think the court said there's obviously other religious and other underpinnings for that argument, and it simply ought not to be a deal breaker.
It's not to be a deal breaker, and it's just something that the court believed was just pretext. The judge just said this is a pretext. This is no different than interracial marriage disapproval that existed 50 years ago, and this is just analogous to that. So again, we're covering this very recent news about same-sex marriages being recognized in Florida. We'll be back momentarily with my guest, Jeff Brown. We're going to take a moment to hear from our sponsors. Stay tuned.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Wwnn, Flynn & Kubler. Our law firm specializes in elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. We offer elder law services, including estate planning, long-term care planning, and preparation of healthcare documents. We strive to plan for your future needs while allowing you to retain as much dignity and independence as possible. To find out more or to make an appointment, call 954-563-4814. That's 954-563-4814. Or visit us online at www.oltmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. My guest in studio this evening is attorney Jeff Brown. He's a partner with the law firm Laval, Brown, and Wwnn. And we have been discussing the recent news about same-sex marriages being recognized in Florida. I'd like to move on to some of the procedural issues with this case. There was a question up until very recently as to whether the ruling from the federal district judge up in Tallahassee applied to all clerks. In other words, his order that same-sex marriages be recognized would apply across the state, or would it only apply to that particular clerk in the lawsuit. And in a very recent order that the judge issued on the scope of his ruling, he said that it did apply across the state and did warn that any clerk in the state of Florida that refused to issue a marriage license to same-sex marriages would be potentially faced with additional lawsuits. So what's your take on this, Jeff?
Well, the first came the order, then came the clarification. So I'd be concerned if I was a clerk and decided not to follow the clarified order, which is issue marriage certificates. I know Palm Beach is honoring it, and the order is pretty clear to me. I'd be hesitant to consider it ambiguous.
Right, and they would potentially be faced with additional lawsuits or potentially contempt of court if they failed to follow the court's order.
Federal judges have multiple authorities and multiple ways of enforcing their orders, even separate lawsuits, and even in this particular lawsuit, federal judges have quite a lot of authority.
Right, and in fact, it's hard not to think of the integration of colleges and that occurred in the 60s when they sent federal agents down to accompany students as they were being escorted to classes.
I like to say that the federal judges trump the state officers and clerks of court, I should think.
And the reason that it is that the federal judges trump the state officers is because they are interpreting the Constitution, the U.S. Constitution, which is the supreme law of the land.
Kind of goes all the way back to our founding fathers, frankly, where
Right.
They had a United States and everybody had to play by the same rules within all the states.
In fact, the argument in favor of banning same-sex marriage often is that it's up to the states to decide what they want to do with marriage. But in this case, and the judge ruled that ultimately a constitution puts limitations on the states.
By squarely putting it in the 14th Amendment and the liberty and calling it a fundamental right, that takes it away from states being able to do what they want and kind of has a uniform federal fundamental right, constitutional right, and that's where it's going.
Now, here, Pat Bondi, who's the Attorney General for Florida, tried to appeal to the circuit court, the 11th Circuit, which is the next level of appeal up from the federal district court, to ask for an additional stay. That is, the court issued an injunction or issued an order essentially saying that clerks had to issue marriage licenses to same-sex couples. Pat Bondi and the Florida Attorney General asked to extend the stay that would not require the clerks to issue those licenses. And the circuit court, the 11th Circuit Court of Appeal, ruled that it would not extend the stay. So to me, it looks like it's put to rest.
Yeah, stays are interesting because what it means is we're going to wait till there's a further ruling by a higher court. And for the 11th Circuit not to issue a stay seems to suggest that the court's order is effective and needs to be followed. And it looks like it's, in that sense, over.
Right, and there were a number of related cases on same-sex marriages from other states that the Supreme Court passed on. They did not decide to hear the case. So in combination with that, it really looks like it's over. Same-sex marriage is going to be here to stay in Florida.
It looks as though it is here to stay.
Right. So, I know we were discussing earlier, you heard rumors, I've heard some rumors online that in protest, some of the clerks of court might not be issuing marriage licenses. do you think that's really going to happen? Or?
Well, I don't know their basis for deciding that they do not have to follow a rather clear and clarified order. So I'd be hard-pressed to counsel them that they can do so without risk, because I think there is quite a risk to a clerk not abiding by the federal judge's order.
Right. And where do you think this sits in the sort of broader scope of actually recognizing same-sex couples as being a group that has constitutional protection, in the sense that we had the United States versus Windsor case back in 2013 when the Defense of Marriage Act, or DOMA, part of it was struck down. A very significant part was struck down, the portion that defined marriage as being an opposite-sex couple.
Well, certainly DOMA started the process, and this is a continuation of it. And that's what I mean when I say I think it's here to stay. And we'll look back years from now and probably suggest that it was inevitable.
Right. And I'd like to talk a little bit about fundamental rights, because we've talked about the right to marry being a fundamental right, but there are other fundamental rights as well. You know, you have the right to travel freely, the right to vote. These are things that are right up there. These are federally protected rights. And you know, there's another issue that you've had had some experience with assisted suicide. I mean, you've been involved in some cases with that as well.
Yeah, right to die is another issue that's now being debated, and the extent of that right is being debated now. The right to die,
and the right to die, that being really going back to medical privacy and the right to choose what type of medical procedure you're going to have done. That being a fundamental right, versus the state's interest in preventing suicide. It kind of is similar to this if you think about it, because suicide is something that people are morally disapprove of. But now we have, in this case, we have the judge saying that moral disapproval is not really a reason anymore. So this might have some influence on other issues outside of same-sex marriage, quite possibly.
I think it will affect other 14th Amendment kinds of cases and what rights are fundamental, and if it rises to that level, then you may have a similar argument being made.
Well, in fact, what the court ruled here, and is really the basis for what led up to this historic moment today, is that that opposite-sex couples really don't have a basis to complain about same-sex marriage being recognized. In other words, the rights of an opposite-sex couple really are not infringed in any way by allowing same-sex couples to get married. That's the court's rationale, and that's one of the biggest arguments in favor of the recognition of same-sex marriage. You could use that argument with assisted suicide as well. You know, you say that what basis does somebody have for trying to impose their will on somebody that wants to die? I mean, isn't it it's pretty much almost the same argument?
There is an argument that it is a fundamental right, and that the state does not have a compelling interest in trying to restrict something. Now, that doesn't open it up that the state has no interest, but the whole right to die is being debated as we speak.
Right. So it'll be interesting to see how these cases work together. As we're going forward with recognizing the right to marry as fundamental, and we've seen, I believe this is the 19th state that there have been challenges to same-sex marriage bans, and every single one, the federal courts have found that the bans are unconstitutional. So it's just going to be interesting to see in the remaining states that have those bans, what's going to happen.
Well, I think it's here to stay, and I think the other states will have to come in line.
Right.
Because the rationale is the same, state to state. Texas, Florida, it's no different.
And it's, one of the other things that the judge brought up in his ruling is he said 50 years later we might look back on this and really be somewhat appalled by the arguments in favor of the ban on same-sex marriage as being just really sort of disingenuous pretext for discrimination.
Well, the history of the law has kind of borne that out, and laws change, and we may look back and say, was there ever really a true argument, or was it, pretextual?
Pretextual, very much like with interracial marriages and other things of that nature. Like they say, the arc of justice is slow, but it bends towards justice and equality.
The law changes with the people, and we're subject to change.
We're subject to change, right? So, if you could tell our listeners how they could find you in the event that they're in need of your services, and if you could give us a little bit more information about your practice.
Well, you can find me at 750 South Dixie. You can call 561-395-0000, or you can find us on the web at Lavelle, Brown, and Wwnn, PA. My practice has been a general practice. I've been in Boca with the same law firm since 1976. So we're pretty much here to stay. Certainly one of the longest standing law firms in the city. And in that sense, easy to find, nor is the name difficult.
Right. I'd like to give a special thanks to my guest, Jeff Brown. You've been listening to Talk Legal. I'm your host, Jeff Van Treese. Tune in next week, Tuesday night from 6 to 6:30, where my guest will be elder law attorney Ellen Morris. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com, or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and